everyone. I'm Rita Peters. I'm the Senior Vice President for Legislative Affairs with Convention of States Action. And today we are bringing you coverage of the Ohio Senate General Government Committee in their third hearing so far this year on the Convention of States application on the Senate side, SJR 3. Now, the hearing yesterday was a little bit different than what we were expecting. We were expecting this committee to hear opponents' testimony only. That's typically what they do. But thankfully, they changed it up a little bit this time. And for this third hearing, they allowed anyone to testify, all parties. So we did hear from opponents, but we also heard from a few supporters testifying in support of SJR 3, the Convention of States application. One of them was Michael Ferris. So what we're going to do with our coverage today is we are going to show you the testimony, the complete testimony of those three COS proponents, including Michael Ferris. You'll get to see that. The committee chair did limit testimony in this hearing to 3 minutes per witness. So it's not much. It's going to go by quickly. After you hear from the proponents, we are going to show you clips of the opponents testifying, and we'll make sure we give you, the flavor of their testimony, and then I will give you a little bit of commentary in response to each clip. So that's the plan for today. Producer G, let's start rolling that footage.
Chair Rogner, Vice Chair Gavrone, Ranking Member Blackshear, and members of the committee. My name is John Bruce Fowler from the Village of Oak Harbor in Vice Chair Gavrone's 2nd District. I'm a retired United States Army Lieutenant Colonel of the Military Police and subsequently a now retired Special Agent of the Federal Aviation Administration. I graduated from The Ohio State University with a degree in political science, and in 2022 was elected the County Central Committeeman for the Salem 2 precinct that I currently represent. I've kept active promoting youth shooting sports and safety for scouting activities, 4-H, and the civilian marksmanship program. My wife and I have 4 grown children and 8 grandchildren, from a 3rd grader to a college sophomore. First, thank you, Chairwoman Rogner, for actively processing SJR number 3 in your committee in this, the 136th session of the Ohio Legislature, and thanks also to your fellow chair in the House doing the same. The bill was heard in committee in the House in the 135th session and in committee in the Senate in the 134th session, but the same legislator who chaired both committees did not hold timely hearings and left them unvoted upon at the end of each session. I'm told in politics that's called letting them die. In the military, we would call it gun decking, i.e. hiding something below decks out of sight. So again, thank you, Chair Rogner and your committee, for bringing this legislation to the forefront early in the session. While standing on Lexington Green on Concord's Old North Bridge and on Boston Common 2 months ago with my wife and a grandson, thinking about that day 250 years ago and thinking about my Revolutionary War ancestor, Private Jacob Bonham, I was moved to think about this legislation. I thought about why the founders put Article 5 into our Constitution, and more importantly, why each state at the time ratified that Constitution, and every state established since has agreed with it to join with us in the United States. The founders were scholars who knew clearly the weaknesses of men and the historical procession of governments that led to tyranny. Well-intended, no doubt, for the greater good, surely, but those governments were still a threat to our God-given freedom and liberty at the heavy hand of some far-removed political collective. Article 5 is the safety valve the founders gave us, the people, regardless of party. This legislation has been introduced in other states by members of both parties. All of us have suffered the heavy hand of lifetime entrenched politicians, fiscal irresponsibility, and devastating regulations not raised by wise legislators, but fiscal irresponsibility, administratively put in place by unelected appointees. Now, all of you have heard in committee the merits and protections that the founders wisely included and the further protections this legislation as written will provide. As we move to celebrate our 250th year of independence, I ask that each of you vote to pass this legislation forward from this committee and then again once on the floor. If not now, when? If not you, who? Thank you for your attention, your vote, and may God continue to bless Ohio and these United States for another 250 years.
Thank you for the opportunity to be here. Just very briefly, I'm the co-founder of the Convention of States movement. I'm a constitutional lawyer, been in practice for 49 years. I've argued 2 cases in the United States Supreme Court and have litigated an Article 5 case involving the attempt to change the process for ratifying the Equal Rights Amendment. I represented 4 Washington state legislators in that case when I was a very young lawyer back in the late 1970s. This is a little bit of a deja vu. I think I argued an Ohio homeschool case in this chamber many, many years ago, so wow. It's great to be here. There are 3 quick questions I'll try to answer in less than 3 minutes. First is, why did the founders give us the process that we were given? George Mason stood on the floor of the Constitutional Convention with about a week remaining and said, if Congress is the only body that can propose amendments, Congress will never propose amendments to reduce its own power. And our government was founded with one basic overarching principle. No one group of senators should have too much power. That's why we have federalism. That's why we have checks and balances. That's why we have all kinds of infrastructure built into our government so that no one group of government should have too much power. And specifically, they said someday the federal government will abuse its power. When that happens, the states need the ability to change the process so that the federal government stops abusing its power. The second question is the federal government abusing its power? And I would quote 2 famous Americans. One is Thomas Jefferson, and one is Bart Simpson. Bart Simpson would say, like, duh. Thomas Jefferson say, we would hold that truth to be self-evident. Means the same thing. There is no doubt, and I won't go into any further details on that. The third point is this process safe? And first of all, we need to understand the nature of the process. We're in the process of setting the agenda for an Article 5 convention, properly called a Convention of States. It can be called an Amendments Convention as well. It is not a convention where you can amend the entire Constitution because it's not called for that purpose. The purpose is binding and it matters. We've had 450, approximately, applications for a convention in the history of our country, well more than 34 states. But we've never had one because there's never been an agreement on the subject matter. You have to agree on the subject matter. People will claim conventions can do anything they want. No, they can't. The Republican National Convention cannot nominate the Democratic candidate for president, nor can it pass laws for France. The convention is limited to the subject matter, and I'd be glad to go in questions to that. I would urge this legislature. My wife and I have 10 children. I understand what would happen if you don't discipline your kids. You have the power of discipline over the federal government. I'd urge you to use it.
Good. All right. Thank you for your testimony today, Mr. Ferris. Are there any questions? Senator Timken.
Thank you, Chair. Thank you, Mr. Ferris, for your testimony. You briefly addressed the limitations there would be upon the delegates and this convention in terms of subject matter. We have heard from many groups that are concerned about a widening of the agenda for this. Is this me? Sorry. I must be buzzing today. A widening of the agenda so that other amendments could be excluded, for example, the Second Amendment. If you could address those and specifically the mechanism for why this would only be a convention to address the specific issues that you have just talked about.
Madam Chair, members, Senator Timken, there are multiple layers of protections against such an eventuality. First is there is a clear rule that has been established by legal precedent, that includes the case that I litigated on the ERA. You can't change the rules in the middle of the stream for the process of amending the Constitution of the United States. The ERA issue was relitigated in the last 2 or 3 years by efforts to try to reopen that in violation of not only the first time limit, but the second time limit as well. And there was a claim, well, there is really no time limits at all. And the courts Every judge that has heard that case says no, whether they were Democrat-appointed judges or Republican judges, every single judge has said, when they've looked at these cases, you can't change the rules in the middle of the stream. If a convention is called for one purpose, that's the purpose. And there would be further litigation that could stop that again. Second, there's a political answer. 34 states will be coming to a convention for the purpose, if ours passes, 34 states will be coming for the purpose of limiting the power of the federal government. Now, how you get to a majority within that convention to grant greater power to the federal government or reduce the powers under the Bill of Rights, which are not germane, is a political fantasy. There are crazy bills introduced in every legislature in the world. Congress, every state gets bills, and nobody pays any attention to them because people can count. And I would simply say simple, basic electoral political arithmetic shows you can't get the votes. And the final stage of the process is anything that comes out of a convention has to be ratified by 38 state legislatures. That's both houses in 38 legislatures. So 13 chambers that say no, the answer is no. And so the idea that you could do that, I mean, we'll take the Second Amendment as an example. By the way, I used to be on the Education Committee of the NRA as appointed as one of the members. I'm a lifetime member of the NRA and had the support of Gun Owners of America when I ran for Lieutenant Governor of Virginia. And so the idea that you could get this, I mean, approximately 25 states have constitutional concealed carry right in their states. How are you going to get 38 states to ratify a repeal of the Second Amendment under that? I can count 20 states that would vote it down within an hour, much less within the process that it would take. So the final argument that's raised here, and the one that offends me the most, is this. People defame the Constitution of the United States by saying it was the result of a runaway convention, that they were called only to amend the Articles of Confederation. But that's just not true. If anybody's ever read the Articles of Confederation, the Congress of the Articles of Confederation that supposedly called the convention had no such power. They couldn't call any conventions. They didn't have any implied powers. The body that called the convention, the bodies that called the convention, were the state legislatures. And their instructions to their states, 11 states was exactly what I'm about to say, is to render the federal Constitution adequate for the exigencies of the Union. That was the purpose of the Constitutional Convention. And I've written an article in the Harvard Journal of Law and Public Policy. You can find blog posts that disagree with me. But my article is in the Harvard Journal of Law and Public Policy that definitively proves the United States Constitution was lawfully adopted, the convention was not runaway, and was ratified properly. The arguments that you'll hear today against the Constitution, a person that claims they're a constitutionalist and yet says the Constitution was illegally adopted is like saying, I'm a Bible-believing Christian, but I don't believe the Bible is the Word of God. You can't have it both ways. If you're a constitutionalist, you've got to believe in the integrity of the Constitution. And their arguments at every level go to the integrity of the Constitution and undermining it. By the way, final point I would add, the first and second presidents of the John Birch Society that today raises a lot of money opposing us, they supported this position where they proceeded to do the Liberty Amendment that got several states to call for an Article 5 convention many years ago. It was a pretty good amendment. I would have supported it if I was in a legislative chamber. And that's simply, I don't know where they get this revisionist history. Not only do they undermine the founders, they undermine the founders of their own organization.
Okay.
I'm John Kersey, here today not on behalf of any special organization or interest. I'm a citizen in Senator Rogner's district, Senate District 27, and I'm personally convinced that a convention of states is the only way to prevent a meltdown of our federal government and the ruination of our country. First, allow me to share some research which I did recently. I teach at Cahuga Community College in the Cleveland area, and I was wondering, what do 18 and 19-year-olds think about federal term limits, a balanced budget, wasteful government spending? To find out, I conducted a survey of students in 2 COM 1010 Fundamentals of Speech Communication classes. Of the 31 students who responded to the questions in the survey, 87% of them supported a constitutional amendment to balance the federal budget.
Commissioners from all 50 states
About
have come here
77%
for the
of them
first
support
ever.
federal term limits. And when asked about how much of the federal government spending is wasteful or inefficient, 97% said either some, most, or all of it is wasteful. 97%. Details are on my blog site if you want to look. It's at ioncleveland.com. Second, consider that checks and balances ought also to work properly between our state and federal governments. As Mr. Ferris said, in an article written for the Harvard Journal of Law and Public Policy, Robert Nadelson, a senior fellow with the Independence Institute, believes that calling for a convention of states is essential to restoring federalism and that states need to rein in a runaway federal government. Now, Nadelson is an excellent company. In one of his Federalist paper, founder James Madison wrote this, quote, "The powers delegated by the proposed Constitution to the federal government are few and defined, and those that are to remain with the state government are numerous and indefinite," unquote. What Madison and our framers wanted was federalism in the sense that much of the power to govern would reside at the state level and not in Washington. They sought to prevent a runaway federal government. Need proof? Look at the words in the Constitution itself. The word Congress is mentioned 23 times. President is mentioned 30 times. The word judicial just 6 times. And the words state or states are mentioned 174 times in our Constitution. Finally, let me finish with a thought from Abraham Lincoln. Lincoln's train made 3 stops in Ohio on its way to Washington, D.C. for the 1861 inauguration. When in Cleveland, Lincoln said this, quote, "If all do not join now to save the good old ship of the Union this voyage, nobody will have a chance to pilot her on another voyage." Ohio senators, that ship is in great danger right now again in 2025. And if you don't take action right now on SJR 3, its failure is imminent.
Very good. Thank you, Mr. Kersey, for your testimony today. And are there any questions for this witness? No, I have a question for you. So several state senators and reps have expressed a concern that calling for a convention of states will really make a difference. What is your opinion of that?
Two thoughts about that, Chair. First, to quote a phrase from an old movie, a convention of states has the virtue of never having been tried. Why would you knock something down if it's not been tried? Right? Everything else is just hot air. All right. Second is, it has made a difference in the past. I did a bunch of research prior to coming to this testimony today, and I discovered that the 17th Amendment, which is the one that called for the direct election of U.S. senators, actually had a convention of states behind it. And at that time, our nation needed 32 states in order to have that convention. The U.S. Senate completely turned down repeatedly a House of Representatives bill that would have created the direct election of senators. But when we got to 31 of the 32 states necessary to call a convention, that Senate turned around 180 degrees and passed that bill. And 38 states adopted that, and that became our 17th Amendment. So I would contend that a convention of states can make a big difference in terms of what happens at the federal level.
Okay, folks, so that was the proponent testimony. I think you'll all agree with me. They did great. That Ohio team is always dynamite. I always love to see them testify. And of course, we can never get enough of our true constitutional expert, Michael Ferris. So now we're going to transition into the opponent testimony, and we're going to start with Ambassador Alan Keyes.
I'd like to ask just a simple question. If the Founding Fathers who originally came together to achieve that result could be assembled and they could constitute some kind of constitutional convention for our day, I think I'd go to bed at night very comfortable with the thought that we would survive that convention. But when I look at what is going on in the country today, including the elements of the adversarial opposition of our parties and things of this kind, I'm sorry. a constitutional convention that was not for this and that, but for what? Well, the purpose of, looking at our present situation and deciding what to do about it would be like the first constitutional convention. They would be able to do, at the end of the day, whatever they thought they would be able then to present to the American people so that it would be effective. Do you all really think that that's going to be a safe result? Because I'm not sure. We are no longer sure that we're a nation that believes in government of, by, and for the people on the basis of what led them in the first place to withdraw from Great Britain, which was the notion, a very simple notion, of the laws of nature and of nature's God.
Okay, folks. So I will say I was a little surprised when I learned that Ambassador Alan Keyes was on the witness list to testify at this hearing, because I had never seen him write anything about Article 5 or had never seen him speak about Article 5 before. And with all due respect to the ambassador, it's probably better that he hadn't. It seems like he's coming in cold a little bit, like he just isn't understanding the point of an Article 5 convention to propose amendments on specific topics, which is what Convention of States is all about. He's talking about a constitutional convention, right, that would operate the same way as the 1787 Constitutional Convention. And that is absolutely not what this is about. This is not about rewriting or writing a new constitution. This is about proposing constitutional amendments to the Constitution that we already have and we all love. So sorry, Ambassador Keyes, but you just didn't quite get it. Okay, our next opponent is Robert Tuttle, and he is just a perennial favorite of the Ohio Article 5 naysayers. So let's go to Robert Tuttle.
We've heard testimony already that there has never been an Article 5 convention before, and the only convention that was anything like it was our 1787 convention.
Okay, so I asked producer G to stop it right there because he is right that there's never yet been an Article 5 convention, but he's totally wrong in suggesting that there's no precedent and that the only convention that's anything like an Article 5 convention was the 1787 Constitutional Convention. That's just absolutely not true. The 1787 Constitutional Convention was one in a long line of interstate conventions. In fact, throughout American history, before and after the founding, there have been meetings of the states in what they call interstate conventions. We have a rich history of it. We have full records of these meetings and how they operated. And it's important to note that they always operated the same way in all the important regards. For instance, one state, one vote, always worked that way. Secondly, the states that participated chose their commissioners or delegates and gave them instructions. And thirdly, there's never in American history been a runaway convention. The convention delegates have always obeyed their instructions and have always done what they were sent to do. Another important thing that has always been the same at all these interstate conventions, of which we know there have been more than 40, is there's always a limited topic set out in advance. The states don't just send delegations to a convention with no agenda and say, go do something and then report back. Of course not. They always have a set agenda or purpose for their meeting, and they've always complied with that limitation. Okay, producer G, let's go to the next clip of Robert Tuttle.
There is nothing in the United States Constitution that would give the states control to either appoint the delegates, frankly, or to control those delegates once they were appointed. And in fact, Congress, we know for fact that Congress believes that it has the power to determine how delegates are selected for a convention and to impose rules on how those delegates would have to behave in that convention, not the states.
Okay, so folks, there are a lot of words and phrases used in the Constitution that aren't specifically defined. The processes aren't all spelled out. The rules aren't in there because we know from history what they mean. For example, habeas corpus, trial by jury. You don't see written into the Constitution all the specifics of what those phrases mean or how those processes work. And it's the same for an Article 5 convention. As I said a few minutes ago, the founders all knew how such a convention would work, how the basic rules went, and how it was operated by virtue of the fact that most of them had participated in interstate conventions many times. It was just a common sort of process, a common event back then, and everybody knew how it worked, so they didn't need to spell out all of the details. And as I said before, we know that the states participating in those conventions were the ones who defined the topic, chose and instructed their delegates, and they were the ones represented at the convention. That's the way it always worked. Secondly, I want to respond to what he said about Congress controlling the convention or setting all the rules. I presume that the evidence he must be relying on are something referred to as Congressional Research Service reports. And those reports don't have any legal weight or binding authority. They're essentially an organization that's gathering data, who's saying what are the different, allegations that have been made about how this thing works. And then they compile all of that together in a report. It has no legal weight, no legal authority. There have been a few instances back a long time ago where some bills were presented in Congress that would purport to set the number of delegates, for instance, or, have something to do with how the convention would work. They failed miserably. So if those are evidence of anything, they're evidence of the fact that even Congress knows that it can't do that. One other thing I want to say about that too is just last year, maybe 2 years ago, Mike Johnson, before he became the Speaker of the House, but just before then, conducted hearings in Congress and brought witnesses in to talk specifically about the Article 5 convention process, because they can see that momentum is growing for the first ever Article 5 convention. And I think it's important to note that it was very clear, if you go back and listen to that hearing, to both the expert witnesses who testified, one was from the Heritage Foundation, and also listen to the comments of the committee members, it's very clear that they do know how the process works, that it is a state-controlled process. So yeah, sorry, Robert Tuttle, but you were wrong on that. Next, we're going to go to, this has got to be my favorite for today. We're going to hear from Mrs. Ellen Horton. Producer G, go ahead with that first clip, please.
I ask you to stay focused on the diagram. Do you have the diagram that I sent? Okay. As I speak, because I'll be referring to it several times. The Article 5 Convention provision in the United States Constitution is clear about certain things, but it's vague, vague about others. And I believe this diagram clarifies the intention. The structure of it, the basic backbone of this one exaggeratedly long sentence is the Congress shall propose amendments to the Constitution. Okay, that is the way that our laws have been passed since the beginning of this nation. And it has worked successfully. Not everything's beautiful, but it has worked. And the second proposal is for Congress to call a convention. Okay, Congress calls a convention, and the Convention of States movement is very adamant about the fact that whoever calls the convention is in charge. And I have to agree with them. Okay, if they call it, it's theirs. And that concerns me. Okay, I'm going to reiterate. Okay, the two methods that they've adopted for that they created in order to amend the Constitution is Congress shall propose amendments to this Constitution. Okay, that's the way it's been done. Congress shall call a convention for proposing amendments. Article 5 itself gives the authority to Congress, not to the states, to call a convention. Whenever two-thirds of both houses of Congress deem it necessary, so the Congress has to recognize the necessity of it, and it has to be under these circumstances, under the application of the legislatures of two-thirds of the several states. So the states are authorized to do two things: to recognize and declare the necessity of amendment, and to apply to Congress for the amendment. Article 5, the wording of Article 5 itself gives Congress, not the states, the right to call the convention and to propose amendments. So the idea that the people of the states, that the states themselves propose the amendments, is contradicted by the wording of Article 5 itself. And you can see that plainly in the diagram. The call to have a convention the right to do that is given to Congress, right there in the wording of Article 5.
Dear Mrs. Horton, I think she seems like a very sweet lady, and we did find out in the hearing she is an English teacher, and I think she's probably a very fine English teacher. And we're going to show you her diagram that she specifically asked these committee members to look at, and she referred to it multiple times. So before I talk about the diagram, though, I want to say, I think her overall point here is that Congress calls the convention, because if you notice, she keeps coming back to that. It's Congress who calls the convention. And that is true. Article 5 clearly gives Congress the duty to call the convention upon application of two-thirds of the states. The problem is that term doesn't mean what she thinks it means. The party who calls the convention doesn't control the convention. It doesn't control all of the other parties who attend the convention. No, of course not. Think about, again, all of the conventions that have been held in American history. For instance, Virginia has called multiple conventions. That means it says, I think we should have a meeting to talk about this thing, and let's convene at this location on this date to have the meeting. And then the other states respond. So under Article 5, when Congress calls the convention, all that means is that once it receives applications for a convention by two-thirds of the states who agree about the topic, Congress sets the date and time for the meeting. Congress doesn't control the people who participate or set up the rules. Just like Virginia didn't decide who was going to represent Pennsylvania at a convention, Virginia didn't get to unilaterally set the rules for the convention. It just doesn't mean what she thinks it means. And now, Producer G, if you'll show the diagram again, I want to point out something about the diagram. First of all, I want to point out that it's a beautiful diagram. And from what I remember from English class, it is correctly diagrammed. But the problem is Mrs. Horton kind of messes up what this diagram tells us when she starts saying that Congress has to deem it necessary before calling a convention. No, look at the diagram. Those are on two separate parts of the diagram. Congress shall propose amendments when it deems it necessary. That's Congress proposing amendments. But then if you look down at the second part, Congress shall call the convention when it receives applications from 2/3 of the states. So she's a little bit mixed up on what her own diagram means. And with that, let's go to the second clip, Producer G.
Will Congress consider the amendments that are suggested by the states, or will they advance their own choice of random amendments? And again, looking at the diagram, you can see that it is Congress that proposes the amendments.
Okay, yeah, that is so incorrect. It is so utterly incorrect. And again, if we can throw the diagram up one more time, Producer G, she's suggesting that Congress is always the one that proposes the amendments, but her diagram clearly shows otherwise. When Congress calls a convention, it's the states that get to propose the amendments. So, and one more thing I'll just point out is that we know that not only from the structure and text of Article 5, as she has brilliantly illustrated here, but we also know that from history. And maybe that's a piece that Mrs. Horton is missing, because we know for certain by virtue of James Madison's notes on the Constitutional Convention that the whole reason the Founding Fathers added the convention process into Article 5 was because they wanted to make sure there was a way for the states to bypass Congress in achieving needed amendments, particularly if the national government should become too powerful and abusive. So sorry, Mrs. Horton, it was a beautiful diagram, but you're wrong on some pretty important facts here. Okay, next opponent witness is Barbara Burkard.
Going from town to town, hawking their cure-all elixirs. Elixirs they claimed would heal all sorts of ailments. Many innocent people, desperately wanting a cure, eagerly bought into the elixirs. These elixirs also often contain dangerous ingredients such as opium, mercury, and arsenic. They came to be known as snake oil. Today, there are organizations that travel from state to state claiming a cure for the ills of our nation. One such group, called the Convention of States, wants us to buy their elixir, which is also called the Convention of States. By the way, that term is never found in the Constitution and not in Article 5 in particular. It's a made-up name specifically designed to convince American citizens that through their state legislators, they can control and rein in the federal government.
Okay, 2 points I want to make on this clip before we go on to one other clip of Barbara Burkard. First of all, note, she is calling the Article 5 convention process that was crafted by our founding fathers and is part of our Constitution snake oil and an elixir that we are selling. That is profoundly disrespectful. It's disrespectful to our Constitution, and it's disrespectful to the founding fathers who created that process and put it into Article 5 of our Constitution to give the states a check on an overbearing federal government. It's not snake oil. It's part of the Constitution. Secondly, she is dead wrong in saying that the term Convention of the States is a made-up term. I would refer her to the case of Smith versus Union Bank. Back in the 1800s, the Supreme Court referred to the Article 5 convention process as a convention of the states. I would refer her to the founding fathers' reference to the process as a convention of the states back during the ratification debates for the Constitution. And I would refer her to the states themselves, and specifically the Commonwealth of Virginia, which called the process a convention of the states when it made the very first ever application for an Article 5 convention to propose the Bill of Rights back in 1788. Barbara Burkard, you're wrong. You need to get your facts straight. Next clip.
We would have to add amendments and/or pass new legislation to force change. In reality, all we needed was a new president. This is my personal opinion. President Trump is already reducing the size of government, eliminating waste and fraud in government, bringing back manufacturing and jobs to this country, protecting citizens from dangerous criminals and gangs, protecting our borders, instilling pride and thankfulness for our military and first responders, promoting love and respect for our country, our flag, and our Constitution.
Okay, folks, so Barbara Burkard loves President Trump. I get it. President Trump has done some great things for the country. However, I submit that she's way off in suggesting that we can now just all rest on our laurels and we don't need to worry about anything with the federal government anymore, because I want to point out that anything President Trump does through executive action or even through legislation, it can all be undone with the very next president, the very next Congress. Those changes are not permanent. If we want to see permanent federal reform, it's going to take the process of constitutional amendment to do it. Next up, we have Joseph. I didn't catch his last name, but I know that he is from the Green Party. So producer G, let's see Joseph.
Nice to see my senator, Senator Gavarone, here, because I've tried repeatedly to set up a meeting with her to discuss this bill, but so far I've been completely shut out.
I'll ask you to keep your comments to the bill, please. Thank you.
Sure. But I think perhaps what's being remembered there is a time when I met with a senator, managed to meet with a senator to talk about HB 6, and we explained in that meeting all the problems with that bill, how it would hurt ratepayers, the environment.
So we're going to keep your comments to the this bill before us today.
All right. Well,
Thank
I'll just mention that.
Not House Bill 6. Thank you.
Right. But the reason I'm mentioning that is because after much pain and many years, this body has managed to fix some of the mistakes with House Bill 6.
Okay, so I asked producer G to include this one really just for a little bit of levity, but also to give a couple of tips to our COS supporters who might be planning to testify before a legislative committee someday. Couple of tips we can get from this. Stick to the topic at hand. Here we see Joseph clearly wants to talk about HB 6. And that is frustrating to the chair because HB 6 is not the matter at hand today. Also, if you noticed, he insulted his own senator who is on the committee publicly by calling her out on not accepting a meeting with him. You generally want to avoid insulting the committee members. Okay, we do have one more clip of Joseph that I wanted to show you.
Now, those same dark money forces are demanding that you pass a truly ruinous legislation overturning the Constitution itself. As state legislatures, in fact, every amendment in the Constitution currently ensures our liberty has been the result of many years of work, anguish, and sometimes blood shed by Americans who for 250 years have been seeking a more perfect union. That search has made us the most powerful and important nation on earth. Don't throw that hard-fought wisdom away. Don't tear up the Constitution. Reject this bill and SJR 6. Let it die here in committee as bills are supposed to do. And I just very quickly want to say.
Okay. Again, for amusement, first of all, the idea that Convention of States is all about dark money wanting to destroy the Constitution. It's conspiracy theory. Secondly, I found it very interesting how he reveres and loves our Constitution's amendments, but he's here to say we better not go for any more. Right? And then finally, I found it interesting and amusing for him to suggest that the proper thing to happen in any committee is for bills to die there. Okay, that's enough of Joseph. Next up, and I apologize again, I didn't quite catch her name, but next up for the opponents, we're going to hear from the Executive Director for Common Cause.
Now, no judicial, legislative, or executive body would have clear authority to settle disputes about a convention.
Okay, so just have to put down that myth right there. That absolutely isn't true. We have literally scores of court cases dealing with Article 5 legal questions. So the number is approaching 100. I don't think it's quite 100 court cases yet, but courts can and do settle disputes regarding various Article 5 questions. Okay, next clip, Producer G.
Also, there is just not sufficient legal evidence to support the claim that a constitutional convention could be limited to one subject or limited subjects.
All right, so the power to limit the subject or the topic of an Article 5 convention is inherent in the state's power to apply for an Article 5 convention, right? It wouldn't make any sense to say that the founders wanted to give the states the power to bypass Congress in achieving needed constitutional amendments, but then not allow them to decide what the topic is for those needed amendments. It just doesn't make any sense. Also, again, we know from an unbroken, universal history of interstate conventions throughout America's history that the states always defined the topic for an interstate convention. They always set out the subject matter for the meeting, which is what allowed the other states to decide if they wanted to participate or not. So we know that from history. And then finally, we know that the subject matter limitation on a convention of the states matters because it's the reason we've never yet had an Article 5 convention. Over 400 state applications for Article 5 conventions have been filed throughout American history. The reason we've never had one is because we've never had 2/3 of the states agree on the topic for that convention. So Common Cause lady is incorrect. The states can absolutely and will limit the scope of an Article 5 convention. Next up, we have Joe Wolverton, and I'm pretty sure Joe represents the John Birch Society. We have 2 clips of him, so let's go to that first clip, Producer G.
Someone pointed out, I wanted to paraphrase Shakespeare from Julius Caesar when he said, "The fault, dear senators, is not in our Constitution, but in ourselves." The COS people can never point to the clause in the Constitution that is the cause of our current crisis, because that's not the problem. The problem, Brutus, the fault is not in our stars, it is in ourselves. We do not know the Constitution, and we do not enforce the Constitution. Therein lies the problem.
Okay, so Joe says that COS people can never point to specific language in the Constitution that is problematic. So I'm going to do it right now. The General Welfare Clause, the Interstate Commerce Clause. The issue here is that the words don't mean the same thing to people today that they meant to the founding fathers when they drafted that language. The issue is we need more detailed, more specific limitations on federal power so that it's not so easy for Congress and even the courts or the president to stretch the meaning of constitutional language that is honestly a little bit vague. Congress having the power to tax and spend for the general welfare. That's a little bit vague. We can make it much more specific. We can put in black and white language that says that Congress's power to tax and spend can only be used in pursuit of its specifically enumerated power. That's just not how it's interpreted today. So we can add more specific, detailed limitations that do what we all know needs to be done, which is to tie down our federal government even more closely with the chains of constitutional language. So hope that helps, Joe. And we have one more clip of Joe.
17th Amendment gutted the power retained by the states by turning the senators over to the people as opposed to the states as the founders intended. That increased the power of the federal government, yet that was ratified.
Yeah, so he's talking about the 17th Amendment, which did take away the power of the states to appoint the senators that represent the states in Congress. And he's right, that was a blow to state power. And I think it's unfortunate that the 17th Amendment was ratified. But here's the thing. He's opposing the Article 5 convention process, which actually is another source of constitutional power the founders gave to the states to allow the states to check the power of the federal government. And it doesn't make any sense that, he's so concerned about the 17th Amendment having given away that power, and yet he is opposed to the single greatest power that the states still do retain under Article 5 of our Constitution. So, folks, that's all the clips of the opponent testimony that we have for you today. I hope you have enjoyed this and found it educational. I once again want to just give kudos to our wonderful Ohio team. They have been brilliant and professional throughout all of these 3 hearings that we've had so far. No word yet on when this Ohio Senate committee will actually vote on our COS application, but that is the next step in the process. So stay tuned and we'll keep you posted. Thanks for watching, everyone.